You've been charged with a felony in Oklahoma and now you're panicking. You've never been arrested before, and suddenly you're looking at prison time, court dates, and the risk of a permanent criminal record. And if you handle this the wrong way, you could lose your job, your license, and even custody of your kids. I'm John Cannon, criminal defense attorney and former prosecutor here in Oklahoma. In this video, I'll show you exactly what you need to do next to protect your future so you don't make a single mistake and you give yourself the best possible shot at keeping your record clean and your life intact. Stay silent and ask for a lawyer right away. If you're charged with a felony in Oklahoma, the first thing, let me say again, the very first thing you need to do is stop talking. Shut up and lawyer up. Whether you're in handcuffs, sitting in a police car, or standing in your own living room, or here is the big one, a detective calls you after your arrest to clear up a few points, you have the right to remain silent. Believe me, I've been in countless situations where someone talked themselves into a much tougher spot because they thought they could talk their way out of it. Let's clear something up. Police officers might seem friendly, or they might act like they're trying to help you get your side of the story. But in reality, anything you say can and will be used against you. That's not just a saying, it's true. And it happens to plenty of Oklahomans before you. Even simple innocent details can get twisted around. You don't have to explain yourself to tell your story. You can simply say, I want to speak to a lawyer. That's it. In Oklahoma, as soon as you ask for a lawyer, the police are supposed to stop questioning you. This is thanks to your constitutional rights, and it's a powerful protection. So remember, don't answer questions. Don't sign anything. Don't try to plead your case to the cops. Just ask for your attorney. This is the single best move you can make to fight back when you're staring down potential felony charges. Gather and protect evidence immediately. After you've asserted your right to a lawyer, the next step is to protect any evidence that could help your defense. This isn't just about what the police find, it's about what you know. Maybe you have text messages that show where you were during the alleged crime. Maybe a friend can confirm your alibi. Or perhaps there's video footage from a business, doorbell camera, or a parking garage that proves your side. This is time sensitive. Surveillance footage can and does get erased in days, sometimes hours. Witnesses' memories fade fast too. If you wait, crucial evidence might disappear forever. Here's an example I see over and over again. My client is accused of felony theft. He tells me where he was at work across town when the theft supposedly happened, but he waited a week to mention it. By the time we checked, the store's cameras had already recorded over the tape. That evidence could have set him free. So, as soon as you can, write down everything you remember. Where you were, who you were with, what you were doing. Save messages, photos, or receipts that back you up. If others can vouch for you, ask them to jot down what they remember as soon as possible. All of this can make an enormous difference in your case. Number 3, understand what you're charged with. Don't assume anything. Every felony in Oklahoma is different. Maybe you're facing drug distribution charges. Maybe it's assault, burglary, or something else entirely. Don't just take the officer's word for it about what you're accused of. Ask to see the actual paperwork, your information. This will clearly state the law you're alleged to have broken and the basic facts supporting the charge. Let's say you're accused of felony possession with intent to distribute a controlled substance in Oklahoma. The difference between simple possession and misdemeanor and possession with intent to distribute can mean the difference between probation and potentially years in prison. Prosecutors sometimes overcharge cases, meaning they go for the most serious version of the charge, even if the facts may better support simple misdemeanor possession, not distribution. If you don't know exactly what you're up against, the prosecution must prove 4 felony charges. You can't defend yourself effectively. A good lawyer will explain the charge, what the prosecution actually has to prove, and what penalties you could realistically face. For example, in Oklahoma, most felonies are punishable by at least 1 year in state prison, but there are exceptions and alternative sentences. Knowing where you stand right from the start is how you begin to build your defense. Never miss a court date or deadline. People underestimate this point all the time, but it's critical. Once you're charged with a felony in Oklahoma, you'll get a court date, usually the arraignment or your first court appearance. Missing this court date is a huge mistake. It's not just a hiccup. If you skip court, the judge will immediately issue a warrant for your arrest. Now, instead of just facing your original charge, you're looking at the possibility of new charges for a failure to appear, plus a likely much higher bond, making it more difficult to get out of jail the second time. Oklahoma courts move fast with felony cases. There might be hearings where evidence is discussed, plea deals are offered, or bonds are reviewed. Missing any of these puts you at a disadvantage. And here's something people don't always realize. Even if you have a great excuse, like a car accident or medical emergency, the judge might not accept it without proof or the right paperwork. If you're working with an Oklahoma criminal attorney, we can help keep you on track. We'll remind you of your dates, file motions to reschedule when necessary, and make sure your rights are protected at every step. But you have to stay in touch. My biggest advice, as soon as you're out of jail, put every single court date in your phone's calendar with a reminder. Then let your lawyer know about any conflicts right away. This little bit of organization can make a huge difference in how your case turns out. Do not talk about your case with anyone but your attorney. This one is huge, and it trips up more people than you can imagine. After you're charged with a felony, you might feel desperate to talk about it with your family, friends, coworkers, or even on social media. Don't. Just don't. Every word can come back to haunt you. Let me share a story. A client of mine, let's call him Mike, was accused of felony assault in Oklahoma City. Mike thought he was venting to a friend about what happened, but it turned out that friend was already talking to the cops. Everything Mike said got repeated in court, and it made his defense much harder. The only person you can truly trust to keep your conversation private is your attorney. Your communications with your lawyer or their staff are confidential. Nobody can force us to reveal what you tell us in private, not even the judge. Social media is just, if not more dangerous. Never post about your case online. Never. Prosecutors and police are checking Facebook, Instagram, even Snapchat for posts and messages about criminal cases. I've seen posts that looked harmless, memes, song lyrics, even vague comments, but they can get used as evidence of motive or intent. The rule is simple. If you wouldn't want a judge or the jury to read it, don't say it, and absolutely don't post it. Work with your lawyer to build a defense strategy. You're not fighting your charge alone. Your attorney's job is to guide you through this mess, and together, you'll come up with the best plan for your situation. But this works best when you're open and honest from the start. Tell your lawyer everything, even if it makes you look bad. I can't count how many times a client left out an important detail, thinking it didn't matter, only for it to blow up later in court. Your defense might involve challenging how the evidence was gathered. For example, in Oklahoma, police need a proper warrant to search your house or car. If they don't have one, any evidence they find might be thrown out if they can't prove exigency. Or maybe there's a question about whether you really intended to commit a crime. Intent is a huge factor in most felonies, and proving it beyond a reasonable doubt is the prosecution's burden. You and your lawyer might also gather character references, employment records, or proof of community involvement. All of these things can show a judge or the prosecutor that you're not just a crime you're accused of. Sometimes pointing out a history of good behavior can make a big difference in the outcome of your case. Know your rights and the possible outcomes. After all these steps, you need a clear understanding of what could happen next. Felony charges in Oklahoma can change your life, but the process is not set in stone. With the right approach, you have options, like getting charges reduced, entering a diversion program, or even winning a dismissal in some cases. For example, Oklahoma law gives first-time nonviolent offenders special programs that can avoid a felony conviction, such as drug court or deferred sentencing. In some cases, your lawyer can negotiate with the prosecutor to drop some charges in exchange for a plea deal to a lesser offense. Sometimes an aggressive defense at trial can lead to a total acquittal, charges case dismissed. But you can only take advantage of these options if you know about them. That's why it's so important to talk everything through with your attorney and make informed decisions every step of the way in your case. Let's recap and your next steps. So if you've been charged with a felony in Oklahoma, fighting back means acting quickly and smartly. 1. Stay silent and ask for a lawyer. Remember, shut up and lawyer up. 2. Gather and protect evidence right away. 3. Find out exactly what you're being charged with. 4. Never miss a court date or a deadline. 5. Don't talk to anyone but your lawyer or their staff about your case. 6. Work hand in hand with your attorney to build a strong defense. And 7. Know your rights and keep an open mind about possible outcomes in your case. If you follow these steps, you're giving yourself the best possible shot at a fair result. But there's more to the story. So if you're wondering, should I take my chances at trial or work out a plea deal? You need to watch our next video, Criminal Trial or Plea Deal. How do you choose the best option? where I break down exactly how to make the smartest choice in your situation. You don't want to make a life-changing legal decision without real knowledge. So click over now and let's keep building your best defense. I'll see you over there.